Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann. On Saturday, December 6th, voters in Louisiana will take to the polls to decide several runoff elections. Today, we're going to speak to a candidate in the runoff election who is running for judge in Jefferson Parish, Danyelle Taylor. Ms. Taylor is facing off against Thomas Anselmo Jr. for the seat of Division O of 24th Judicial District Court. Mr. Anselmo declined to participate in this forum, citing a scheduling conflict. If you would like to learn more about Mr. Anselmo and his platform, you can visit his campaign website at anselmoforjudge.com. Coming up after the break, we'll talk with Danyelle Taylor about the role of 24th Judicial District Court, the challenges the court faces, and much more. So stay tuned and we'll be right back. Welcome back to the show. On Saturday, December 6th, our guest will run in a runoff election for Judge of Division O at 24th Judicial District Court in Jefferson Parish. Division O is an open seat, meaning there is no incumbent, as the outgoing judge, Ross Ledart, is retiring. Attorney Danyelle Taylor joins us now for Power of Attorney. Welcome to the show.
Thank you. Thank you for having me.
Okay, let's jump right in. How would you define the role of a judge?
I think the judge is the final arbiter of truth. People come into the courtroom, they tell their stories, and they're in conflict. A judge has to decide resolution. It doesn't matter if we're talking about a divorce case, if we're talking about a personal injury case, or if we're talking about a criminal case where the state has accused someone of a criminal offense. Okay. In the end, the judge is the final arbiter of what really happened, and he makes the call.
So, speaking of all these types of cases, for the position, the judge position that you're hoping to be elected to, can you define what kinds of cases you would be handling if elected to Division O at the 24th Judicial District Court?
The district courts in Jefferson Parish, they're not segregated as in other parishes. So this court will hear criminal felony offenses. It hears all of the family law cases, divorce, custody, support. And it also hears personal injury cases or contract matters, usually over $25,000 when you're talking about a monetary dispute. But if you had a dispute with property, or if you had a succession and an interdiction, this court handles all of those types of issues.
That's a broad spectrum. So what about your legal experience qualifies you to be able to deal with so many different types of cases and to deal with them properly?
Well, I think what's important in this particular case is that we have a judge who actually has been in the courtroom trying cases.
When you say trying cases, there are some people out there who maybe don't know what that means. What does it mean to try a case?
It means to actually put a witness on the stand, to conduct direct and cross-examination. It's not just oral argument. It's about making evidentiary objections, about putting the appropriate exhibits or witnesses into the record so they can be considered in the judge's decision. And whoever is the next judge of Division O, I believe the people need a judge who has actually been in that courtroom doing those sort of things. My opponent doesn't have any trial experience, and he's admitted in a public forum that he has never tried a case. On the other hand, I have tried hundreds of issues before the 24th Judicial District Court. I've been in court, should I say, trying cases on a regular basis, having my clients testify. I represent actual people that live in this district. My clients have been residents of Jefferson. I've also had cases in probably the 9 surrounding parishes as well. I have had quite a number of cases in Orleans due to its proximity, as well as Jefferson Parish. But my clients have pretty much been the people who live and work here, not big business interests, not insurance companies. And to me, that perspective of having to know what it's like to have a client, and basically to bring a client into what seems to be a foreign place. The clients don't always know that what goes on in TV drama is not actually what goes on in a courtroom. And sometimes I think it's somewhat of a shock for them. So I think that we need a judge who's had those sort of experiences, who understands what it's like to represent ordinary, everyday people and to bring their cases to trial.
Okay. Let's change gears a little bit. What do you see, having spent time in 24th Judicial District Court, as you mentioned, what do you see as the most pressing issue facing the court today?
I think we also are, coming from a lawyer, it may sound strange, but I think that we've had a growing number of pro se litigants, or people who have attempted to represent themselves.
That's what pro se means. People who don't have their own lawyers, they're trying to represent themselves, and they're not lawyers.
That's correct. And it could be an insurance dispute, it could be a flood or hurricane claim, and they've chosen not to get their own attorney. It could be a family law matter where they've chosen not to get their own attorney, or
fighting over child custody or child support, for instance.
That's true. Someone who may owe them money and they're trying to file their own suit. I'm on a committee actually in the 24th Judicial District Court that actually just started a help desk 2 days a week. And it's funded by a grant, and we have pro bono attorneys, meaning we have attorneys who serve voluntarily for no pay, a couple of hours a day, twice a week, so that people who want to represent themselves can come to the court, and they will be guided in how to fill out or prepare their own pleadings to be filed with the court. It's a little tenuous because you have to remember that these attorneys can't be giving legal advice, but the court gets strapped into that position when you have someone who's filing a pleading and it doesn't really meet the legal requirements of the law, and a judge can't tell them how to fix it. So this is a service that the Jefferson Parish has decided to provide to the public. I think we recognize that that seems to be a growing need and a growing concern, and I'm happy to say I was part of the committee that actually implemented that program in the court system.
So if I'm understanding you, the idea is to try and help people. They're trying to help themselves, but they don't have the legal education and experience to go into that courtroom and properly help themselves. So the idea is to try and avoid train wrecks from happening. In other words, maybe they really are owed money by the other side. They're trying to fill out a form properly and make the other side pay the debt that's owed, and without some guidance and some assistance, their case might get thrown out, and this committee that you're on gets other lawyers to volunteer and donate time and assistance to give some guidance.
Correct.
Okay.
Just to let them know, if you file a petition for this kind of relief, A, B, and C have to be in the petition. Without actually writing it for them or telling them exactly what to say, they can give them what the law requires for them to get their hearing, to have their day in court, to get in front of a judge.
Okay, all right. Well, that brings me to, it's coincidentally, my next question. We read in the papers, and maybe some people see online or they see on the news, that there's always this challenge of limited funding in our courthouses, not just in Jefferson, but everywhere else. This issue of limited funds to have our courthouses run properly and to serve the community. What would you do to determine how best to use the court's limited funding? Sounds like what you just described is one good use, but what else?
I think in recent years, Jefferson Parish has done a very good job of doing well with their funding. We have a pretty new, by most parishes' standards, courthouse, part of the annex that was redone, and I don't know if you've been there. There's an atrium that joins three of the buildings.
I'm there on a regular basis. I'm a practicing attorney.
So you know what I'm talking about. It looks nothing like what it did when I first started practicing.
I remember the old courthouse, and it's
I remember it too.
Condition.
Yes, 18 years ago when I started practicing, it looked nothing like what it looks like now. So I think they've done a really good job with facilities, and I don't know that I could ever say, well, gee, they should have done X, Y, or Z. They should have done something different, because I think that they've been good stewards of those funds to make that project happen the way that it happened. And insofar as court personnel, I have to tell you, I have not noticed in Jefferson Parish that there's any shortage of personnel, or that the personnel doesn't seem, paper doesn't flow like it should, or it doesn't. I really have not had a lot of complaints.
So you see a lot of good. Maybe there's some room for improvement.
There may be some room for improvement. I think in the help desk, again, I think a lot of times people are, not people like you and I who go in there to file our own things, and we know exactly what desk. When you walk in the hallway, there's a big long list of desks. You may not know where to go. But I think in this, the way they have it set up and the people who are running it at this point, I really don't have any complaints, and I think they have been good stewards.
Well, that's an encouraging note. All right, well, another question, and it's related. Census figures from 1990 to 2000, 2010, and other data show that the gumbo of the greater New Orleans area, including Jefferson Parish, showed that the gumbo, the flavor of our gumbo includes a lot more Hispanics in our community. What would you do in your courtroom to accommodate a lot more Hispanics? Victims, Hispanics involved in filing suits, being part of the crime concerns. Do you have any response to that?
Well, I think you've just given me an idea, because I'm not sure, now that you said that the help desk employs anyone who does speak a foreign language, and that may be a benefit. I don't know whether there's been any language barriers problem. It's been running since October of this year. And I think that may be something we should look at, is whether or not we need to make it a point to have someone who speaks Spanish there, who can help some litigants, and also have, I think what's important is to have it posted in the courthouse somewhere in Spanish, that service is available to them. Because it's one thing to provide the service, it's an entirely other thing to make sure everyone knows that it's available, what it is, and that they can use it. But in my courtroom, obviously, as you know, when you have clients, and I have used an interpreter actually on 2 occasions, and I think one was for Spanish and one was for Vietnamese. I believe that the court has to be sensitive to those issues and to make sure that lawyers know exactly when interpreters need to be provided to the court. It's an aid to both for their benefit and it's an aid for our benefit. But in the end, if we want justice to prevail, then obviously we have to be able to understand, and the litigants need to be able to understand. There needs to be a flow of communication. So
it's an access to justice issue as well.
Exactly. It is an access to justice issue. That is exactly correct.
Okay. All right, next question. What do you think is the most important qualities that a district judge, such as the post that you're seeking, should possess?
Well, I think that the judge needs to have experience in district court. If you're going to ask people to elect you as a district court judge, then you should have been in district court trying cases. And my opponent's admitted he's never tried a case in district court. And I've tried many cases. But I think it's important from the perspective of the bench that they understand not only what's happening right there in that moment at the trial, but they also understand what it's like to take a case to trial. Because as you know, most of the work's not really done right on the spot in the courtroom. It is done weeks and months in advance in preparation. Whether we're talking about conducting discovery, deciding what your evidence is going to be, and doing depositions, and then presenting it in front of the judge. And presenting it in a way that's cohesive, that the judge understands it, that it makes sense, that gets you the verdict that you're trying to get in the end. And of course, there's one side wins, one side loses, and they both fight hard for their clients. But in the end, the judge has to evaluate all of the things that he sees or she sees when it comes into her courtroom. And from the standpoint of preparing a trial, when you prepare a trial, you are evaluating evidence, because you're deciding what is seminal, what's important to my case, what's not important in my case. And those things are, I think, that's experience that can't be matched by anything else. You know, the experience is in the doing. It's in the putting the witnesses on the stand for direct and cross-examination, making evidentiary objections, knowing what rules of evidence are going to come into play ahead of time, because you know what the other party is likely to bring up, and you're ready for that. And so you give, each side is presenting their own side to this judge. He looks at all of it and he makes a decision. But I just think the rationale of having been through that process and knowing what it is, it gives you the temperament, the skills, and just the plain everyday practical knowledge that a judge needs.
We have to pause right there, but after the break, we'll continue our Judicial Forum with Danyelle Taylor. Welcome back to the show. We're continuing our conversation with Danyelle Taylor, who's running for judge in Jefferson Parish. Let's get back to our questions. All right, some would argue that to attract the best person for the job, judgeships should offer great benefits, including the opportunity to travel to meet with others in the legal profession and learn the best legal and judicial practices. But others would argue that judges are public servants. They're paid with taxpayer money, and these trips should be scaled back. Where do you fall in that debate, and why?
Well, I guess I'm going to take a middle-of-the-road approach. Obviously, just as attorneys have to get continuing education, we're expected to keep up, so to speak. I think that we have to have our judges do that. There's no doubt that it is just as valuable to have those sort of continuing education forums. I don't think that we should do them to excess. I don't think that it should be in the vein of a paid vacation. And I understand that's why the public is concerned about it when they say, well, we've paid for this judge to go here. I think that a lot of times, and I'm not exactly sure about exactly where the Judicial Council meets every year, but I do know that there's a Judiciary Council for Education, and I do know that they have yearly seminars that you can go to. They may not always be in Louisiana, so I think there may be some times that we are going to have to send our judges there. I do believe that they are paid servants, and it is something that we should furnish to them. I do believe that we should furnish some sort of, whether we're talking about paying for the actual class itself and for him alone to travel, I'm not talking about his family and lodging. I think that's reasonable. I think it's reasonable to do it once a year. I don't think it's reasonable to do it 3 or 4 times a year.
So sort of like all things within moderation.
Exactly. I think the public expects that that's going to happen, but they want to know that it's not something that's being abused.
Okay. All right, another question that we've asked pretty much all the candidates for judges is this concern that we see in the papers about what they call crowded dockets, where judges that either they're asking to be reelected, or they're going to inherit what's called a crowded docket. Lots and lots of cases that are piled up, stacked up, so it's hard for those who are in the court system to get their day in court. What sort of plans and hopes do you have if you're given the privilege of serving as a judge to address that?
Well, I think that I would not be averse to actually holding morning and afternoon hearings. That wouldn't bother me at all. And I think a lot of times it's useful, especially in motion practice, it's useful in some family law practices. I've had the experience of practicing in more than just Jefferson Parish and watching how, quote, other judges and judicial district courts do it. In one parish that I practiced in, they actually had to show up on Monday, and they gave you an appointment to come back and try your case in court at some later time that week, depending on everyone's schedules. I think that's a little too cumbersome to expect of most attorneys. They have their own busy dockets. But I would not be averse to setting both morning and afternoons if I had to do that to sort of break through and get things moving in some cases that might have been stagnating because they couldn't get a hearing.
Okay. Well, that sort of brings us back to this access to justice issue, because there's all sorts of levels and facets to the access to justice issue. And a question I want to pose to you, I've posed to the other candidates in other races, is do you believe that all citizens do have access or adequate access to legal justice? And if not, what do you think can be done to provide wider and better access to justice for all citizens?
I think that a lot of times it depends on the type of case that we're talking about. It is easier to find an attorney who might represent you for an accident if you don't have to come up with money up front. I think for the regular guy who might need to fight a cause and needs to come up with a retainer, it's a burden. And I definitely think that it's a burden where I live on the West Bank. I've done a good amount of family law, and that's one of those types of cases where people are expected to come up with a retainer. And so
retainer is money, a chunk of money, a sum of money paid to the lawyer in order to begin the attorney-client representation, correct?
Right.
And it's difficult for people to come up with, especially when they're in a difficult domestic dispute situation, child custody or fighting child support requests, things like that, correct?
Correct.
Just make sure our viewers keeping up.
And well, I've seen in other cases, I've done succession work where the parties did not have money to open the succession. It might have been a house that was damaged in Katrina. There might actually be funds there to fix it up,
Succession
sell
is when
it.
someone has passed away and the property that was in that person's name needs to be basically put into the name of the people, the descendants or the family members who would inherit those things.
That's correct. And then they could choose to do something with it. They can sell it and turn it into funds for themselves, but they have to get title. In order to get title, you have to do the succession. And those sort of people, it becomes a problem for them just to get someone to be able to do that. I think things like the help desk would help in those situations, and that's good. But I think also what you're talking about in your question prior regarding access to justice, you know, sometimes continuing or keeping to continue a case where someone is paying an attorney to appear, they pay a court cost every time there's a minute entry made. And when those people keep having to come back because their case wasn't heard that day, because the docket was crowded and we just didn't get to it, then that is justice denied. And that is a judicial access issue, in my opinion. And I can tell you that from my point of view, as the judge or as a person who's had that happen to them on behalf of their clients and understands my clients' struggles, it's definitely something that as a judge I will be seeking to avoid. I think that if you're paying attention to your docket and if you're understanding I've got to move these cases here, or if I've got to have more hearings on more days, maybe there might be some flexibility that I could expand my civil docket into my criminal week if I am not having any criminal trials, because as you know, everything is sort of broken up into weeks in Jefferson Parish.
Okay. All right, well, we're running short on time, so here's the final question. Above and beyond what you've already been able to tell us about you and your experience and credentials and qualities and qualifications for the job, please give us some parting thoughts about why you believe you are the better qualified candidate for the position of, or the post of judge for Division O at 24th Judicial District Court.
Well, I am the candidate who's actually been in Judicial District Court trying cases in those divisions. And I've tried cases in front of nearly all of the judges that are presently sitting. There's a couple of new ones I haven't actually had a trial in front of yet. I have been practicing for 18 years representing real people and real litigants, not big insurance companies. I understand what it's like to have to bring a client who's unfamiliar with the court system through trial and to see things from their point of view. I think that's what gives me sort of a good down-to-earth perspective and temperament as a judge. But I also understand what it's like to have to evaluate the law in a 10-second minute, 10-second time frame, I should say, when you need to be on your feet and making objections, and you need to know this is this rule of law. It has to be applied right here, right now. And those are the sort of experiences that you want your district court judge to have, because when they sit on the bench, they're waiting for you to make those objections. If they were a good lawyer and they were worth their salt, then they are waiting for you. They're going to recognize it too. They're waiting for you to make the objection, and they can't supply it for you. So you need to have your own skill set when you show up there. When you ask people to make you judge, you need to have your own skill set. And my opponent has not been trying any cases in district court by his own admission, and I think it's a big deficiency. And I think that it leaves him lacking a big perspective of how to handle this job as being the judge, being the arbiter of truth, being the person who applies the law evenly and fairly.
I'm grateful to you for that answer, and we actually have to end our discussion here. There are so many important issues and so many more questions to get to, but that's all the time we have for today. Remember, you can learn all about everything we talked about today on our show's website, johnredmannpoa.com. You can also learn where you need to go to vote, watch every episode of the show, and submit your legal questions that we'll try to answer on the air. A special thanks to Danyelle Taylor for participating in our forum, and thanks to you for watching. We'll see you next time on John Redmann, Power of Attorney. Thank you very much.